Hi and welcome. Thank you so much for taking the time to join me as we review the basics of trusts, why they differ from wills, and why talking about estate planning is very important, regardless if you have a big estate or you don't have a family yet. At some point or another, this is going to pertain to you. So let's begin. Firstly, I really like this image because it encapsulates the importance of what we're doing. We take the time to plan for the future by taking photos. We're capturing memories. We know that someday the moment that we're experiencing right now won't exist. And so we want to make sure that in the future, we have something to remember it by. Similarly, your state of health, you being here, this is a temporary status. Someday, something might happen, and there might be some day that you're not here. So what we need to do is take the time to plan for the future so that we can have more moments like this. To begin with, take a minute to answer this question and be honest. If you were suddenly incapacitated, do you have the necessary documents in place to relieve your loved ones of the liability of managing your day-to-day affairs? Furthermore, do you have the necessary documents in place with your medical and financial institutions to guarantee your loved ones can make informed decisions on your behalf? Most people answer no to these questions. And that's okay, because that's what myself and my team is here to help with. When someone approaches me and says, "Hey, can your attorneys draft a will for me?" I'll say, "Yes, absolutely, but I think it might be beneficial to understand the difference between a trust and a will, because they're completely different, and one leaves you very exposed, and one gives you total flexibility and control." So if you're just after a will, I think you're going to enjoy this presentation and understanding exactly how much power you can take back by just having a simple trust in place. Firstly, a will is 100% public. This means that after you pass away, it becomes public record and someone could go down to the county courthouse, pay a small fee, and have a copy of that will so that they can see exactly what you left to whom. They can then go to the court process, because probate means to prove, and contest the will, having their day in court. We want to help our clients avoid this entirely for a variety of different reasons, and we'll go through those. But let's look at what a living trust does instead. So firstly, a trust does not go through probate, okay? We'll talk about the function of that in just a few minutes. It also prevents the court from controlling your assets at incapacitation, because it doesn't have to go through probate. And finally, because of that, it gives you, not the courts, control over the assets you leave to your heirs. So that's powerful by itself. If you decide that you want to leave maybe a house to a loved one, you can pass away knowing that it's going to be very, very, very difficult for someone to contest that. That brings a lot of peace of mind, I think. So how does a trust function? How can it avoid probate? Well, firstly, a revocable living trust is an entity that you have full control over that's tied to your social security number. So it's like an LLC, right? And because what we teach our clients to do is retitle their assets, such as a house, into the name of their trust, the client doesn't actually own anything under their own personal name. Therefore, there's no reason for the court to get involved. Literally, no reason. And it saves so much money. As we'll talk about later in this presentation, probate is quite expensive. Then some people will ask, do I lose control of the assets I put into my living trust? No. You keep full control. You continue to do everything you could do before. You just title your assets into your trust, and when you want to sell those assets, sell them out of the trust. It's very simple. And our team is here to help you draft the right documents so that you can always have peace of mind knowing that whatever you need is within that trust, it's buttoned up, and you don't have, as we kind of tell some people, like a carrot dangling out there in the form of an asset under your personal name. Now, before I move on, let's look at the quote at the bottom. It was John D. Rockefeller who said, "I own nothing, but I control everything." This is someone who's part of one of the wealthiest families in the United States. And regardless of your opinion on him, he understands the function of trusts and tax shelters. And so this is one more individual who knows that if you don't own anything in your own personal name, but you still have full control through a trust, you are the wiser. There are some different roles of people when you set up a revocable living trust. As the person who sets up the trust, you might be called the trustor, or the grantor, creator, or settler, depending upon the state you live in. The trustee is also you while you are alive. Now, the successor trustee is someone you hand pick to manage your affairs in the event that you're incapacitated, and or when you finally pass away, they're going to be the one who settles your entire estate. So it should be someone you trust, and it should be someone who doesn't get too overwhelmed by the concept of having to push paper. Of course, there's the beneficiaries as well. These are the people or organizations who are going to receive your assets. When you pass away, what are the duties of the successor trustee? Well, it's pretty simple. So let's say that you are incapacitated, and that could be from a sickness, like the big C. If you're under the weather and unable to manage your own day-to-day affairs, your successor trustee is going to step in. First of all, you have to be deemed incapacitated by a medical professional who you can determine who that is. And if you're incapacitated, then your successor trustee has the authority to do things like pay your mortgage, make sure your dog is cared for, pay some medical bills, whatever is needed. They're going to keep things rolling so that when you come out of that incapacitation, you can manage your day-to-day affairs. When you pass away, they're going to do all of that but one final time. They're going to collect all monies that are owed to your estate. They're going to pay off debts. They're going to file final taxes, and then they're going to post in the newspaper as well too that you have passed away. And so they're doing all of that but one final time with a few additional tasks there. And I kind of touched on the second one here. If you become incapacitated, your successor trustee is the person who manages your affairs. And don't be scared. They can't just decide that they're going to sell your house and move to Cabo or something like that. Rather, they are legally bound to follow your instructions as you outline them in the trust because it's a legally binding document. And that's exactly what number 4 is about. A trust is a legally binding contract when it is signed. Therefore, you can be pretty darn sure your successor trustee is going to follow your instructions. If they don't, they're liable. And not many people want to take that responsibility on and not do what they're expected to. Next, how a revocable living trust is set up. Firstly, there's a process. So let's say that you say, okay, I'm ready to move forward. I want to build a trust. What do? I'm going to direct you to some paperwork that's going to help you build the bones, as I put it, of the estate plan, which includes a trust. So the estate plan contains 12 different documents, including power of attorney documents, the revocable living trust, medical directives, and end-of-life wishes. There's a lot to it. And then our attorneys are going to give you a quote based on how many assets you own and what it's going to cost to help redraft the titles and whatnot. And this is a one-time fee. Then, after you sign off on the quote, they're going to build this big comprehensive document, which is a very thick binder. Then we're going to set up a 2-hour meeting and we're going to go through it. It's going to be notarized, has to have 2 witnesses, and we're essentially going to make every document in there effective as of that day. Then the important thing is you follow through with what I call your homework. You fund your revocable living trust. Now that doesn't mean you have to set up a trust account. It literally means you just take scans of your titles and your deeds and you send them to our office and our attorneys begin redrafting them. Funding is moving assets into your estate plan, specifically in the trust. That way they're not in your own personal name, right? They're in the name of the trust. So for instance, my name is Mandy Freilich. We have the Freilich Family Trust. The Freilich Family Trust owns our assets, but I don't own anything on paper, so that's how that works. It's important to change your beneficiary designations and also to note possible exceptions. Why? Because, of course, it gives you maximum control over the proceeds even after you die. And, of course, one of the things we recommend to clients is that once you have your trust set up, update the beneficiaries on your retirement accounts. Let's say you have a 401k plan. Take your wife or your husband off and change it to be the name of your trust. You can be sure that it's all going to still flow through after you pass away exactly as you want, because the trust is a legally binding document that outlines exactly how distribution to beneficiaries should be managed. I kind of touched on probate a little bit earlier, but let's go into it a bit more. So probate, to prove, is when the court and attorneys get involved to help settle your affairs. It's proving the validity of the will, and it's leaving it exposed. It's also reducing the amount of money that your family is going to have after you pass away, because probate is often quite expensive. I mean, when you think of paying a lawyer, do you think of paying them in like $20 or $40 per hour type frame? No, it's always in the thousands. So we want to save money first and foremost. And these numbers, 8 to 12%, have actually changed in the past few years. In some states, it's upward of 18 to 24% of an estate that can be lost before any final debt or taxes are paid, just by having to prove the validity of the will. Now, probate takes less time, so that's one of the perks as well too. In some states, it's taking up to 2 years to settle a estate through probate. I don't know about you, but I'd rather just be done with it after it happens. With most estate plans, it takes about 60 to 90 days to settle the estate. And it only takes 60 days because that's how long you have to post into the newspaper. But by creating an estate plan and having all of your assets in a revocable living trust, you're essentially pre-probating your estate so that after something happens, all the family has to do is essentially follow through with your instructions. Done. As I mentioned, a will is 100% public. A trust is not. Now, get this. In order for someone to see your living will within the trust, different functions there, they would have to sue every single individual listed in the trust, including the grantor, including the beneficiaries, including anyone else listed, and that becomes a very timely and costly venture. So most people aren't going to pursue litigating against a trust. It's not worth it. And lastly, and I think this is the most important one, it minimizes emotional stress. I like to tell clients, at the end of the day, when someone's on their deathbed, you want the family around them, right? You want to allow them to really spend the important time that they need to with their loved ones. They shouldn't be in the hallways speaking with lawyers and trying to get last-minute documents signed. So if we can minimize that emotional stress, and we can minimize emotional stress by pre-probating the estate so that the family doesn't have to spend 2 years trying to wrap up all different types of loose ends, then we've done our job. Some additional benefits of setting up a revocable living trust for your family include avoiding multiple probates. If you have land in more than one state, your family is going to have to go through probate multiple times. That's not fun. Secondly, it prevents court control of assets at incapacitation. There's no need for your family to have to go to the court and have their involvement to determine who can make decisions on your behalf. And there's no concern that whomever is going to make decisions for you doesn't get it right. With the successor trustee, they can immediately step in. No court involvement needed. A revocable living trust also prevents court control of a minor's inheritance. With these documents drawn up, your successor trustees can step in and use your assets to provide for your minor children. You can also stipulate delayed inheritance, such as once they turn 18, they get 5% every year until they're 25, then it's 10% until it's liquidated, for instance. And that gives you full flexibility and control. Additionally, you control when your beneficiaries inherit. So as I just mentioned, assets can be distributed right away, or they can be delayed. I mentioned earlier as well, a trust is more difficult to contest. Because it's private, the contesting heir must hire an attorney and sue every single person listed in the trust. And of course, as I mentioned before as well, it's essentially pre-probating your own estate. So it's much easier for the family, and that minimizes emotional stress. So the question here is, if you can have full flexibility and control over your affairs, you can save your family emotional stress, you can reduce the amount of time it takes your family to settle your estate, you can give them assets, which we didn't talk about this yet, on a stepped-up basis, which means that they can avoid capital gains tax and pay tax on the asset based on the same day you purchased it at. Why wouldn't you? Why wouldn't you have these documents in place and make sure that if you're incapacitated, there's a plan for it, that you know exactly how your life is going to be handled, who's going to make decisions for you, that they have all of the adequate permissions needed to speak with your financial institutions and your doctors and have their authority recognized. Why wouldn't you? A revocable living trust might not be perfect, but there's simply no other plan that can give you all of these benefits and so much control. That's one of the reasons that Black Hills Financial Planning works with Foundational Wealth Partners. We believe that this service and being able to provide the revocable living trust in an estate plan is invaluable. It does so much for families. And so if you have questions, I urge you to reach out. Get in touch with me. You can visit foundationalwealthpartners.com as well, speak with another agent. But at the end of the day, learn more and ask questions, because this is the time to familiarize yourself with what trusts are, with the difference between trust and wills, why it matters, and then go do your homework. Thank you.